in possession, you were alleged to be in possession of 80 kilograms
I
of
was
coffee.
not found on the location, my lord.
You are not. They say that your identity cards were found in the vehicle.
No,
You're
responding
not
to the identity card, my lord.
You're not the registered owner of the
I am
vehicle.
not the registered. I have placed it on record, my lord. The registered owner says in his cross-examination, he has been cross-examined.
Allegation is that the vehicle has been transferred in your favor.
He says, but in the cross-examination, he says he cannot confirm if the vehicle that has been alleged to be found by the police is the same vehicle which he sold to me, even otherwise, my lords.
All right, we'll issue notice here and keep it after 2 weeks. Serve the standing counsel for
I'll
the
serve.
state of Madhya Pradesh.
I'm most grateful, my lord.
Issue notice, returnable on liberty to serve the standing counsel for the state of Madhya Pradesh. He has been denied, Antonio.
Most grateful, my lords.
Item 2.
Very short question is what is the
There's a
relevant?
delay of 235 days.
There is a delay, my lord, because
Why
of
should
the
we condone the
evidence.
delay?
My lord, there was.
And look at it this way. When they first filed their claim before the tribunal in Madhya Pradesh, you objected to the jurisdiction of the tribunals, relying upon the judgment in VA Tech. True,
Fine.
the judgment in VA Tech has been overruled subsequently.
now.
But at that stage, at your behest, he was sent to the arbitrator. You didn't object to his
By the
jurisdiction
High
before
Court,
the
my lord.
arbitrator.
By the Honorable High
Right.
Court.
But then you never objected before the arbitrator. Now there's an award.
It's a matter of record that we objected only at the stage of 37, my lord. I
37.
cannot
So-
quarrel with that.
We'll dismiss it. What we'll do is we'll dismiss it on the ground of limitation so that it doesn't become a precedent in any other case. And we'll
Question
keep the
of
question
law.
of law open. There's a delay of 235 days in filing the special petition against the judgment of the Madhya Pradesh High Court dated 9 December 2022. Full stop. There is no satisfactory explanation for the delay. Full stop. Hence, the petition is dismissed on the ground of delay. However, we clarify that since the bar of limitation has intervened, it has not become necessary for this court to express any opinion on the question of law raised,
It will remain open, my lord.
which is kept open. We shouldn't say it's open because actually the question of law is decided in your favor
My
by
lord,
our judgment of
Lions.
2018.
Lions.
Because the judgment in VA Tech has been overruled by our court.
That is
So
there, my
if
lord,
we
but
keep
it
it-
says.
If we keep it open, we are tacitly then casting doubt on our judgment. The question of law is in your favor. Just that we are not interfering in this case only.
At this stage, my lord, if I may only
Then we'll
point
say it's
out,
kept, the question of law is kept open. Fair enough. You want it, we'll give it to you.
I'm very grateful, my lord.
Please, my lords. My lords, this petition has become infructuous because subsequent developments have taken.
Counsel appearing on behalf of the petitioner states that the petition has been rendered infructuous by subsequent
I'm
developments.
sorry, I want the question of the law to remain open, my lords, simply being, my lords, because this is for the second petition, my lords, pursuant to a settlement agreement.
That's all
And
right.
lordship's court
It's
has.
always open qua us.
My
Nothing
lord.
is concluded by us. We are just saying that it's infructuous. Item 4.
My lords, the matter will ultimately be the lordship's court only, so I'm just.
So it's always open qua us. We are saying it's disposed of as infructuous. It can never bind a future bench.
I'm very grateful, my lords.
This matter, admittedly, the NCLT finds that my claim and my allotment to the flat is reflected in the information memorandum, which is the basis of any resolution plan. And it is showing in the record.
What about delay?
Yes, my lords, on delay, my lords, admittedly, I am not present when this pronouncement is made. My lords, the matter is reserved 3 months back. It comes in a pronouncement, my lords, my appearance is not there. I have vehemently said that I was not present. It is uploaded, my lords, and
What is the date on which it is uploaded?
my lords, it is uploaded on 22nd of August 23, from which, my lords, I am within limitation, excluding the certified.
You were not
copy.
present. Were you a party?
Yes, it was my application, my lords. On my application while reserving,
But then if it's your application,
yes, my lords.
then can you say that I was not present? I don't know because,
So, my lords, the arguments happened, the order stands reserved,
but it is,
It's not
when is the order pronounced actually? It's not pronounced at all.
not on the dates argued, my lords, not on the dates heard. It comes up in the list 3 months after for pronouncement.
22nd August.
No, my lords, 11th of August. 22nd August is when it is uploaded and which is when I gain knowledge of the order. And I, my lords, file immediately. I file the appeal immediately.
Learned counsel appearing on behalf of the appellant submits that that in the application which was filed by the appellant, though the order was passed by the National Company Law Tribunal on 11 August 2023.
Yes.
The order was uploaded only on 22 August 2023. Hence, it has been urged that the appeal which was filed on
The appeal was sent.
October 2023.
My lords, 10th October 23.
10 October 2023 would be within the period of limitation of
My lords, 61-2.
the limitation. We'll issue notice,
Great.
returnable on.
My lords, may I only make one request? The resolution plan basis which my application was dismissed, even to date has not been approved by the NCLT. Now, my lords, may I only request for an interim stay until
We'll make it returnable in 2 weeks. Why
Grateful.
stay everything? Serve Dusty and come.
so great.
Yeah.
Yeah, please.
See, in this case, the NABARD, though initially it said that, there may be certain irregularities in the functioning of the bank.
My lord.
Subsequently, it filed an affidavit before the High Court stating that the resolution of the board was proper and that there were no irregularities. Ultimately, this was a public interest litigation. You brought some grievance to the attention of the court. The court has felt that it is not necessary to interfere.
Page 368 may be seen, my lord, for a moment.
What is that?
Ordered by High Court, my lord, Honorable High
The
Court.
earlier High Court, the earlier order.
Yes, my lord. It says, my lord, pursuant to previous order, action taken, report on behalf of the NABARD has been placed on record. Prima facie, certain allegations were stated to be true.
But that is prima facie. Subsequently, NABARD files an affidavit and says that we have now looked at it and there's nothing.
Later, my lord,
Anyway, as a PIL petitioner, your duty was to point it out to the High
Please,
Court.
Lord.
High Court went into it. NABARD is a national bank for rural development. They file an affidavit. Now, why should we?
not the error is page 389 may be seen, my lord. Uttar Bihar Gramin Bank, as well as not the sponsored bank, Central Bank of India was directed to take decision on this erroneous activity. Lord, that is my
But look,
view.
ultimately, as a bank, it is regulated by the state authorities, since it's a state bank, as well as to a certain extent by the Reserve Bank of India. Why should we presume that they will not look into the any regulatory failures in the bank?
Lord, may I submit, not any fraud above 3 crores, Lord, is directed to be investigated by CBI. Lord, here the quantum is not above. More than not 500 crores, Lord, that is.
Sir Counsel, we are referring to the affidavit filed by NABARD dated 21st February 2024, where the averment is that it is humbly submitted that as per the specific directions dated 18 January 2024 of this court, the instances pointed out in the special audit report were scrutinized. On scrutiny, respondent number 4 is satisfied with the resolution of the board of UBGB that the guidelines of fraud are not applicable to the present matter, audit report, and therefore the matter is not required to be referred to local police / CBI as per clause 9.1 and 9.2 of respondent number 4. Sir.
Lord, may I submit, Lord. Initially, Lord, 13.
I think we've made our point clear. I think we'll not entertain it further. It is a PIL after all. Yes, dismissed. Item 6.
Okay.
Item 6. Yes, Mr. Raghunath, you are on the screen.
Advocate Raghunath on behalf of
Filed a writ petition before the High Court for early hearing of your appeal before the DRAT. And now you are in the Supreme Court under 136. We're not going to entertain these kind of...
Your Honor, my lord, these special pleas against the order of the Honorable High Court and there is no supervisor. There is no, about 24 hearings have happened.
What do we do?
But-
The tribunals are, it's not that the tribunals don't have work. They have their own priority.
But my lord, it's a question of recovery of 208 crore
I
rupees.
know, but you are postulating that your case is the most important to be reaching the line or the queue. Other cases may be as important before the tribunal. Why should we expedite your case? We'll not do anything like that. Thank you. Dismissed.
Because this is a petition seeking appointment of an arbitrator. The clause of arbitration which finds place in the SPA was SHA, which was initially disputed by the other side, gradually accepted on an affidavit and recorded by the High Court in its order, saying that they were trying to mislead the court, but they've then accepted the existence of the SHA and the arbitration clause. We had only seeking appointment of an arbitrator because one of the respondents is a Sri Lankan citizen and the other is an Indian citizen, both of them being shareholders in the company, which was created pursuant to the SHA.
My lords, I'm appearing for the respondents hearing. Let them supply me a copy. I'll come back in 2 weeks and give my no objection for the appointment.
For the appointment of the arbitrator?
Yes, my lords, after perusing the agreement, because there was a confusion about the agreement per se,
All right.
their notice of invocation says
Yep.
the arbitrator.
Fair enough. You're appearing for both the respondents, right? You're appearing for
Yes,
both the
yes,
respondents.
yes.
Fair enough.
No, they have admitted the existence
I
of
know, he
the.
doesn't have a copy of the
Let me
papers.
see, that's fine.
He's on caveat. So we'll.
I'm not on
see,
caveat also. I'm just appearing.
Issue notice, can I have your name?
Karthik Malhotra.
Mr. Karthik Malhotra, Senate counsel appearing on behalf of the, states that he has instructions to appear on behalf of the respondents, and seeks a short adjournment to take instructions. A copy of the paper book be supplied in the electronic form to the Senate counsel for the respondents. List on, should we keep it on Monday and finish it on Monday?
Please, my lords.
My lords, Friday is
All right, next Friday.
next Friday.
Very good. Next.
Yeah. Item number 8.
My lords.
The candidate who was selected as the president of the Consumer Disputes Redressal Commission for Mallarkotla,
Sangrur.
as for Sangrur. The candidate who was selected resigned
Within 6 months.
within 6 months, in which case you are the second candidate. You have no vested right for appointment.
Normal.
If the candidate does not accept the appointment, then the second candidate can say that, well, appoint me to the post.
There's only
Once a candidate is appointed, then the select list comes to an end because the process is
Our
complete.
submission was only this, my lord, that the OM says that if a person joins and resigns or vacates within 1 year, then, my lord, the merit list has to follow. In this case, my lord, the OM is there and the judgment of my lordship, 3 judges of this court have said. And my lords, this is since no, that's right, my lord. But my contention is that since this is a judicial selection, instead of going through a fresh selection process, my lord, people can, and I'm there in the merit, my lords.
The government picked out all candidates who are lower in the list. That whole selection process in Punjab was replete with all kinds of
What they have
difficulties.
done is, in my district, Sangrur, after, my lord.
Because the Punjab government thought that they can just pick up candidates who, are, suitable to them, overlooking the select list.
So that's my case. When one resigned, they appointed someone who was not even in the list, who didn't even apply. I was there at number 2. They
But
didn't call
see,
me.
his appointment may be invalid, but
So
you
our-
have no vested right.
So
right?
here, he's R5, my lords, he's R5 here. I said so in my LPA. When the writ was pending before the honorable single judge,
Whom did they appoint?
they appointed one Jyot Karan, who was not even in the select list.
No,
Page
but look at
70 is the select list.
But look at it this way.
Yes, ma'am.
Your plea was appoint you. You're not really concerned about his appointment.
In the writ petition, it was appoint me. When the judgment is reserved in the writ petition, on that day, they appoint this person. I filed an LPA. I said, how can you appoint him? You have to appoint me. The OM is there in my favor. The 3 judges is in my favor.
Did you ever challenge his appointment?
In the LPA.
The LP?
Because in the writ petition, he was not appointed. He was appointed on the day when the judgment in the writ petition was reserved. So I could not have made him a party in the writ petition. I made him immediately in the LPA. I made him immediately in the LPA. I made an application. And he's R5 here before your lordships. A person who is not selected is working, my lord, as a presiding officer of the Consumer Forum. And I was there in the merit list. I was in the wait panel. OM says, my lords, the panel.
Petitioner, the grievance of the petitioner is that the candidate who was first in the select list, right?
Very well.
The candidate who was first in the select list for appointment to the post of president of the Consumer Disputes Redressal Commission, Sangrur, resigned. Full stop. Thereafter, full stop. The petitioner was second
Yes.
in the select list. Full stop. According to the learned counsel, after the judgment was reserved by the single judge,
Yes.
And before it was delivered,
Yes.
the fifth respondent was appointed
Yes.
as the president
Yes.
of the District Consumer Disputes Redressal Forum, though he was lower.
He was not in.
Though he was not in the merit list
Yes.
at all. Full stop. The petitioner has been non-suited on the ground that once the first candidate, was it a fresh appointment then? They just picked him up without
Picked him up without anything.
All right, we have recorded your submission. The grievance of the petitioner, therefore, is that even if he was not eligible to be appointed as the grievance of the petitioner is that the selection of the fifth respondent is completely contrary to law, since his name did not figure in the merit list at all. Full stop. Issue notice returnable on after 2 weeks. Thus the permitted in addition. Liberty to serve the standing counsel for the state of Punjab in addition. You have come here after 280 days delay.
Father passed away during this period. Father was very serious.
280 days is too.
280 days.
And on interest, claim is on interest in addition to the return of compensation.
I invite your lordship's kind attention, but page 19 only. Page 19, just, it has been recognized. It has
What's
been
the point?
approved. Yes.
What's the point that you want to make?
Well, it has been approved. It has been said that yes, this due is there.
You have to open the door. You have to first get the delay condoned.
My father passed away. I have said so. And he was bedridden, and
There's a delay of 280 days in filing the special petition, for which there's no satisfactory explanation. Full stop. The petition is dismissed on the ground of limitation.
I circulated a note yesterday evening.
Yes.
My point is that it's a statutory violation. I'll be under remedy.
Tell us one thing. After the conciliation proceedings failed before the Facilitation Council, you have said that they never called upon you to file a statement of claim. Is
No
that
statement.
correct?
I was a defendant, so no statement